Good afternoon, folks. It's my distinct pleasure and honor to have the opportunity to come before you this afternoon to discuss such an important topic. I was telling Mark that this is quite educational for me. I've discussed this matter on the radio and what have you, but just sitting here in the last few minutes, I've learned more than I knew when I came in terms of what the law, the current state of the law, and what the current progress in terms of the litigatory aspect of the Second Amendment to some extent in terms of the right to purchase and the right to carry. I do a couple of radio shows, and in fact, that's what Brian heard me on the Morgan State radio show. And one of the concerns that I find in the city of Baltimore, well, a major concern that everybody should be concerned with is the crime situation that we're confronted with, which I believe has not only reached outrageous proportions, but has in fact reached emergency proportions. As I had the opportunity to talk to the Washington Post yesterday and give them my perspective in terms of what's happening in Baltimore City. But one of the things also that I've picked up in terms of my callers and what have you, when I am on the media area, is that there's a great fear in Baltimore that all the citizens are now possessed in relationship to the crime situation, but there's a great problem in terms of folks who are concerned about protecting themselves. And the laws that seem to, in fact, dispersuade or bar the law-abiding citizen with the opportunity to, in fact, protect themselves. And so I think this gets into the legal area, as Mark is already aware and explained to you all, as to equal protection of the law. Whether or not I believe that there probably is a disparate impact in relationship to people who make applications for purchasing permits and people who make applications to carry. I would basically take a very, very, I think, intelligent gamble that there's a disparate impact racially in terms of folks who are approved and disapproved. Now, the question is whether or not that creates one of the questions as to how do you obtain this data. Does it come under the Freedom of Information Act, or does it come only through the litigatory process? I was telling a gentleman back there that I was talking to earlier that I have been through this process on two separate occasions. They may not seem relevant, but they are relevant. I brought one of the first major cases in the state of Maryland back in the 70s for profile stops against the state. And we prevailed all the way to the Maryland Court of Appeals and forced the state to, in fact, the ACLU eventually came out and carried the litigation to another level, but it forced the ACLU forced the state of Maryland to, in fact, the state police to give us the statistical evidence in terms of people who were stopped as it relates to being stopped racially and also being stopped in terms of not just the stopping, but what their criminal records were and what have you in terms of the probable cause issue. I also raised this issue and had the opportunity to raise it when I was first trying to be admitted to the Maryland bar. I was denied admission. They alleged that I'd failed the examination, which I deemed to be an impossibility. This was back in the 70s, and African Americans, it was a major challenge to pass the Maryland bar. I brought the first suit in the nation against the state of Maryland, that time the only suit in the nation. And again, we moved and were successful in getting the statistics in terms of the applicants of color and the applicants of non-color and what those passing statistics were. At that point in time, white folk were passing at something like a rate of 80% and blacks were passing at a rate of 6%. That litigation went on to be, in fact, cause some changes in the application process of the Maryland State Bar, because one of the things that they did was identify the applicants prior to you taking the exam. you had to have an interview. And obviously your racial identification was determined at that point in time. So this is not something that is beyond the realm of norm in terms of the statistical information. I believe the statistical information is available because looking at the gun issue, one of the requirements for the permit, as I saw it, you can correct me if I'm wrong, Mark, but one of the things that I saw was race is something that's requested on the application. So if they're requesting race, then obviously they do have the statistical information as to the people making applications, and if they do that, then they also have the statistical application information as to persons who are granted or denied a permit. And so if you're into the litigatory process or the litigation process is moving forward, that probably will have to be one of the basic things to be established in relationship to grounds for a equal protection argument. A lot of law, you've always heard the situations, I'm sure, where law firms will take two applicants, one of color, one of minority, and have them both apply at the same time, and therefore, and track which one in terms of time and what have you, in terms of relevant information as to when the license or the permits are granted. Well, I don't think you have to do that. I think the courts have basically said if you can show a statistical impact and a statistical imbalance, then basically you have established a prima facie cause for the other side to come back and refute that evidence that there's no discrimination. So we have a big problem in Maryland. I'm going through the process now as I speak to you. And I had a license, permit to carry. I never had to worry about purchasing because that handgun purchase restriction, as I understand it, Mark, is relatively new. But back in the 70s, I had a permit to carry and renewed it on one occasion, and then I decided it was just too burdensome, and so I let it go. And so over the years, I just did not carry a firearm, of course, although I've always owned firearms. But as I got into here lately, in terms of what's happening in Baltimore City, what's happening in the nation and in Maryland, I felt the need to be able to have the opportunity to carry a firearm. And moving forward with that, I made application, I think now, it must be at least in excess of 6 months, but it might be closer to a year. The application process is now all computerized. You don't have the paper application, and that struck me from Jump Street because I'm not a computer person. I mean, we all, us older guys, we old school, we want to stay with paper and pen. But certain things have to move us into the 21st century, and so my secretaries, in fact, helped me prepare my application on the computer. But that bewildered me in the first place, why I just couldn't file an application. But having done all of that, the next thing they did, they told me that I had to have the firearm training. And I said, well, isn't there an exception to it? And they said no, but I reminded them that there was an exception as I read the law on the fact that I was a military veteran, United States Air Force, and had qualified as a marksman while I was in the Air Force. So they made me go back and produce my military records to show that I was honorably discharged. So I did that. After I had to go back and find all these papers and what have you, we had to call the Department of Defense and get certain certifications and what have you. Then the next thing, my office is on Ricestown Road. The state police office is on Ricestown Road, but I got a notice that I had to go to Celso Drive in Baltimore County for an interview in relationship to my application. And that was just ridiculous. I'm 5 minutes away from Pikesville, but I've got to get up and drive 45 minutes to Baltimore County to have this interview to give them information that they already had. But I did it. And so then, after the interview with the gentleman, and one of the funny things that happened in the interview, the officer that was interviewing me, we got to the area of references. And so we were going through the application and we were rehashing my references. And while he was doing that, the telephone rang. And I excused myself, and because I was waiting for a call, not knowing that this particular call. And when I answered the call, it was Mike Miller, President of the Senate. And so I said to the officer, I hope that I can take this call if you don't mind. In terms of references, it just happens to be the President of the Maryland State Senate. Could I offer him as a reference? And that was me being humorous. They didn't find it too funny. Well, Mike and I were talking about something else. He was just calling me about something totally unrelated. So he never understood what the joke that I was making with the officer. And I didn't want to bring him into it. So then, after we completed that process, the next thing we got just a couple of weeks ago, that they wanted my business records, deposit slips, and certification. Even though the guy that was interviewing you said, Mr. Pettit, I see you on television all the time. I know you're a lawyer. And we went through that when I had that so-called interview. But now 2 weeks later, I get a letter asking me or telling me that I had to produce this financial information by December 15th, or my application was null and void. So we had to go back and give them bank statements. They wanted not only deposit slips, but they wanted bank statements, and we produced that. And so now, we're however months into this process, I'm waiting for a response from the Maryland State Police of whether or not I'm going to be allowed to have a gun permit, and I'm sure that if they do in fact approve it, it's going to have so many conditions, then it's almost going to make it irrelevant. Now, when you start talking about the conditions, let me just go back and comment on that. As a criminal lawyer, I would say over the past 45 years that I've been practicing law in Baltimore City in the state of Maryland, you would be surprised at the number of gun cases that I have had in terms of representing people who were not criminals, who were law-abiding citizens, and who had a weapon for a legitimate purpose. And yet, they were still cited with criminal citations and arrested, booked, and had to go to court. And I've had judges where we had to produce the gun permits with the restrictions and argue in a court of law whether those restrictions were applicable in a criminal courtroom, or whether there was probable cause to make the arrest in the first place. I've represented at least 5 to 6 or 7 over the years of people who had security jobs and were in uniform and were coming or going to work and were stopped by the police. And the police, in an arbitrary and capricious manner, refused to accept their indication that, hey, I'm coming from work or I'm going to work. And they still had the firearm on them, and the officer said, well, you should have taken it off, you should have put it in the trunk, you should have locked it up, you should have put it in the case, blah, 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 and dragged these people into criminal court with the jeopardy of incarceration simply on a discretionary decision that this person should not, in fact, be carrying a gun, even though that person was in uniform, with a badge, with authority, with a license. They were still prosecuted. So when you start talking about that type of conditions, then you're talking about arbitrary and capricious application of the law. And if you look at the case law, it is my opinion, in talking to Mark, I understand this has been litigated and still being litigated. If you open those decisions to arbitrary and capricious determinations, whether it be by a board or whether it be by an officer on the street, then you're in fact establishing a constitutional basis because you're invading the constitutional rights of that individual that's subject to arbitrary and capricious action. When you have no fundamental standards, when you have no fundamental rights which are dictated, or rights which, or fundamental objective criteria to make these decisions, then you're violating the rights of that individual that is being subject to police authority. So these, in my opinion, these laws that we saw way back in the Heller case, which I'm sure you, as I was saying, you all know more about the law in this than I do, but in the District of Columbia, which at that time was Chocolate City, when they attempted to remove guns, handguns from, and not only that, but all firearms would have to have locks and security and what have you. And the Supreme Court struck that down as unconstitutional, I think in a 5-4 decision. When you see these laws that are being put back on the books under the name of progressive legislation, they really, you have to look at the big picture and say, what are these laws really about? Are these laws, in fact, to protect the public in terms of criminal activity, or are these laws, in fact, to take firearms out of a certain element of the community, or a certain racial makeup of the community, or a certain section of the community? Are these, in fact, designed so that a certain population is, in fact, disenfranchised from their opportunity to bear arms under the Second Amendment? And that's my argument, and I believe that's what I'm seeing. I believe that's what I've seen, and I believe if that statistical data comes forward, that statistical data will bear out the assertions and allegations that I'm making here before you. I do believe that the restricting of the right to purchase, the right to own, the right for self-defense is an imperative and a necessary constitutional right that our Constitution and our government grants us and should not be deprived. I think the right to be able to carry a firearm without being subject to arbitrary determination as to the reason why. If you meet the standards in terms of being a law-abiding citizen, in terms of your mental health and what have you, I believe those restrictions thereafter are unconstitutional and infringement upon the constitutional rights of individuals, and are particularly aimed at the African American community or the economically disadvantaged or people of color. Now, that may be an extreme argument, but that's what I've seen statistically over the years in relationship to my criminal law practice and in relationship to the law and the cases that have evolved in relationship to the ability to own and also the ability to carry and transport. So we're in a very, very serious situation. I speak to people every day. I speak to people that call my radio show, and I have not, once they understand the issue, and people talk about gun this and gun that and the violence and what have you, but when they understand that the criminals are going to get the guns, they're going to get the guns through unlawful manners. They're not going to make an application. They're not going to go through the scrutiny of being subjected to the causation for them wanting a gun, because the causation is negative. But when you turn and say that you're going to put the private citizen at a disadvantage in relationship to being able to protect their family, their property, and their loved ones, that to me flies in the face of the Constitution of the United States and the amendments there too. And so that should be unacceptable, and I applaud this organization for moving in the direction it is doing, Mark and others and Brian, to challenge this in the state of Maryland in terms of it being one of the few states that's still in the dark ages. And, you know, I meant to say also, when I talk to people, men, women, for different reasons, who feel it's a necessity to own a weapon. I do not believe that I could sleep at night or live in Baltimore City if I was not assured my safety and the safety of my family because I have a weapon and access to a weapon. I would not be able to lock my doors at night with all the alarms and everything that I have and rest my head on my pillow and sleep if I didn't have a means of protection. And I think a lot of citizens feel that way. And as I got to my practice, in my early days of my practice, I used to do my own investigating. I couldn't afford an investigator. It's places that I would not go or could not go or nobody should go unless they were armed. But I felt very confident. If I was investigating a murder case and I didn't have an investigator, I had no problem going to the scene to look at the crime scene, to take my measurements, to knock on doors and talk to witnesses. That didn't have anything to do with the aspect of how much money I was transporting to the bank or not transporting. When they ask me for my business records, what are they saying? Are they saying if I'm not moving enough money, then I don't qualify for a permit? If my business is not large enough, then I don't qualify for a permit? When I was a young practicing lawyer, I could do everything that I wanted to do because I felt the security of being self-protected in terms of my law practice, my investigations, my talking to witnesses, and it didn't matter what hours I was at because sometimes I might be out late because I had to meet somebody who was going to tell me about what I was looking for, was a witness to a crime. I remember one case, I was over in Cherry Hill knocking on doors at 1, 2 o'clock in the morning because I was looking for somebody who had seen what I was litigating about. I would not have done that or could not possibly have done it with a reason of sanity if I had not been legally armed. And so this criteria and the things they're talking about, from my perspective, is ridiculous and only designed for one particular reason, and that is to, in fact, limit the ability of people within the urban community and people of disadvantaged economically, to put them through the hoops and the paces of a fee here, a fee there. You got to pay for this, you got to pay for that, you got to go to this training class, you got to do this, you got to do that. Those folks don't have that kind of money. When a little old lady of 75 years old said, Mr. Pettit, I'd like to have a gun in my house. I want to have a gun in my house. I really liked one in my purse when I went to 7-Eleven. I began to understand that when I got 72. I'm 72 now, when I turned 70 years old. You know, I was the athlete, as my wife says, think that I could stop anything and do anything, walk in the streets, I had no fear. But at a certain age, I decided that doesn't work anymore. Too old to fight, too old to run. And so the ability to carry, the ability to purchase, the ability to own for law-abiding citizens who are mentally competent should not be disturbed and should not be abridged.